Tom Giannotti, attorney with the Butler Law Firm. I'm here today to talk to you about a question that unfortunately we get more than we like, which is, can I be fired because of an injury that happened outside of work? For example, a car accident. Now it's important to make this distinction because if you were hurt on the job, then you may have a workers' compensation claim, which is a totally separate matter, and if that does apply to you, please give us a call. We can set you up with a good workers' compensation lawyer. But let's say you hurt in a car accident, for example, and you find yourself unable to work. Well, can your employer fire you? Well, in many situations, unfortunately, the answer is yes, because Georgia is what we call an at-will employment state. That means your employer can fire you for any reason at all, unless it's certain reasons that are protected under federal law, like discrimination, or a couple that we'll go through here. One of those is the Americans with Disabilities Act, the ADA. Now, that has different requirements. Your employer has to be a covered employer, which is 15 or more employees, and you have to be disabled. Well, what's a disability? It's different from what you might think for purposes of, say, disability benefits through Social Security. That's not what this is. This disability is defined as a physical or mental impairment that substantially limits one or more major life activities. So breaking that down, a major life activity, well, working is a major life activity. A physical or mental impairment, well, if you're hurt in a car accident, that's a physical impairment. The question is, substantially limits your ability to work. If you're not able to work, then that's a disability for purposes of this. Now the question is, though, what does your employer have to do? Well, that depends on your job. It depends on your specific situation. But generally, upon giving reasonable notice to your employer, your employer is required to accommodate you within reason. So what's a reasonable accommodation is defined in a whole body of law, but let's just take a couple of examples. If you work in a warehouse where you do a bunch of heavy lifting, you're on your feet all day, and you have a broken leg, well, you're not going to be able to do that job. And if you're not able to do the essential job functions, then you're not going to be protected by the Americans with Disabilities Act, unfortunately. If, however, you're like us lawyers and we're sedentary at our desk all day, and you have a broken leg, well, you can do that in a wheelchair. You can do that with other accommodations. And if your employer has to put you on the first floor, then that's something that's perfectly reasonable for them to do. There are a lot of case law decisions that interpret this, so don't take this as legal advice or anything like that, but it is something that can offer you protection depending on your specific circumstances. So if you have questions about that, please give us a call. Another law that may offer you some protection is the FMLA, or Family and Medical Leave Act. That offers you 12 weeks of unpaid leave if you've worked for the company for at least a year, and you've got to give, again, sufficient heads-up notice to your employer, but they are required to let you take time off, just like if you have an illness or a family member who is ill or passed away. Now, again, there's more specifics to that law, but that is something that you could take advantage of. It's not ideal because, again, it's unpaid, but it may be at least preferable to actually losing your job. And your employer cannot fire you if you qualify for that leave and opt to take it. Another thing, though, that you may have and may not even be aware of is something called short-term disability benefits, and that's just a private, insurance benefit. Your employer may offer it as part of your benefits package, or you may have it through, an insurance company, and that can offer you some wage replacement. It may not be 100% of your wages, but something to get you through that period of time, that difficult time when you're hurting and trying to get back to normal and heal so you can do your job again. that can offer you some coverage if you are taking that unpaid leave and allow you to keep the bills paid and put food on the table, of course. And we hate to see this happen to clients and prospective clients. We really do hate to see people that are having to choose between doing their job and being able to heal. But if this does apply to you, or you have specific questions about your situation, give us a call. We can direct you we're not employment lawyers, but we can also put you in touch with excellent attorneys that are specialized in that field. This is, again, just a broad overview and not legal advice. So again, give us a call if you have specific questions. We would love to be able to help you if this is the situation you're in. If, let's say, you're in a car accident, there's certain things that we can do to help, like making a claim for lost wages. You do, again, have to what we call mitigate your damages, or basically go out and try to look for substitute employment. But that can be a part of your damages in the civil case, and it's also part of your pain and suffering, because of course it goes without saying that losing a job is a very stressful and mentally taxing ordeal that nobody should have to go through, but for something that isn't even their fault. But if you do have the misfortune of being in this situation, that can actually, again, be a recoverable element of your damages in a civil case against the at-fault party. So finally, if you have questions about this, if you're wondering if you could lose your job because of an injury that was no fault of your own, please give us a call. You can reach us at 678-940-1444. Again, that's 678-940-1444. You can go to our website at butlerfirm.com, or you can email us at nci@butlerfirm.com. Thank you for watching.